Hello, everybody. Hopefully you can hear me out there. And to the folks in the room, thank you very much for coming. My name is Matt Lynch. I'm an attorney with the Severs Busto James Law Firm here in Bellevue. I'm speaking today on a topic that has really exploded, I would say. And I'm not usually one to throw words around like that, but the topic that has exploded, particularly in the month of August, involving the National Labor Relations Board, and two cases issued by the National Labor Relations Board that primarily non-union employers really have to pay attention to. And the first one deals with workplace policies, and with the NLRB kind of redoing the rules on what of your employment policies, let's say your handbook policies relating to employees, which of those policies would be considered lawful and unlawful. And then following that decision in early August of this year, 2.5 weeks later, the NLRB issued a huge decision on union elections. And you might think, well, what do these two topics have in common? Well, if I tell you now, then you're all going to log out and go enjoy your Friday afternoon. I'm going to make you stick around to get the answer to that. But we're going to be reviewing all of that. And as we see here on the screen in front of you, I'm going to give you a very brief background on the National Labor Relations Act, which governs union and non-union employers, and that's often missed. So if you're a merit shop employer, you are still bound by the National Labor Relations Act in a very critical way, and we'll review that momentarily. And then we're going to look at how the National Labor Relations Board, or the NLRB's case law, has evolved relating to employer policies. And again, handbook policies. Many policies that over the decades have been considered normal policies are now at risk of being considered unlawful by the NLRB. We'll look and identify what many of those rules are, or what many of those policies are. So this would be an opportunity for you to do a self-reflection, if you will, on your own policies. And I would encourage you all to go back and dust off your handbooks, dust off your policies, and make note of some of the policies we'll be talking about this afternoon. And then we're going to shift gears a little bit and talk about an NLRB decision that came out in late August that completely rewrote how unions can go about organizing your employees. And this, as you would expect, given what everything else you've been reading about regarding this NLRB and its definite union orientation, you're going to see that these two issues, employer handbook, employer policies, and the new process that unions will be following in order to try to gain recognition by you of the employees they want to represent, how those two are related. And there's a little, at the very end, time permitting, there are a few other developments of less import, but still things you're going to need to pay attention to regarding certain policies. Many of you have some of these policies that particularly the state of Washington is forcing you to modify. Okay, so that's what we're going to be reviewing today. I shouldn't have much of a problem. I think we'll end by 2 o'clock or sooner. I would encourage you, if you do have questions, to maybe put those into the chat, and we'll try to get to those. Or if you prefer, go ahead and unmute yourselves to ask your questions. And I'll try to get those answered. Feel free to ask those as we go along here. Okay. So without further ado, the first thing we really kind of need to level set ourselves with is, okay, what's the law here? and we're not going to go into a half-hour explanation of what the statute says and whatnot. But these are the underpinnings of all of the issues we're going to be addressing for the next 90 minutes or so. And the first is hopefully you're all familiar with the National Labor Relations Act, which is the federal law that guarantees employees the right to organize and engage in others, what the statute calls concerted activity for mutual aid or protection. And that law covers private sector employers. It does not cover public sector. It covers private sector employers, both union employers and non-union employers. And the National Labor Relations Board is the federal agency that's charged with enforcing that. So the NLRB oversees the National Labor Relations Act when it comes to private sector employers, and the NLRB sees to it that it administers and enforces that law in a way that will protect employee rights, as well as union rights and employer rights. There are three entities and the three parties in federal labor law that were most the law is written to address, and those are the rights of employees, employers, and unions. Section 7 of the NLRA, the National Labor Relations Act, is like the core of that whole law. Okay, and this is what it says. For the most part, this is verbatim. I took out some language that you didn't need to pay too close attention to, but you'll see here that the law is written, and this is again the centerpiece of federal labor law going back to the mid-1930s, that employees have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing. And here's what we're going to be focusing on today, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. And this, I always like to point this out, and employees also have the right to refrain from those activities. They have a right to not engage in that stuff. So we're going to be focusing on here is this expression that employees have the right to engage in concerted activities for the purpose of mutual aid or protection. Okay. And it's a concept that applies to non-union, merit shop contractors, as well as union contractors and union employers. And when we talk about concerted activities, well, you can imagine there's almost 90 years of case law interpreting, what concerted activities there are. But generally, concerted activities involve the right of employees to get together with their coworkers, or just to act individually, perhaps on behalf of coworkers, or on an issue that is relevant to their coworkers, on matters pertaining to their wages, their benefits, or other terms and conditions of employment. Okay. And you can imagine now that, okay, we have this federal law that's currently in place. Now we have a whole bunch of policies that we have, and policies maybe you've had in place for decades. And what is the interplay? What is the interrelationship between your right as an employer to manage your business and to try to regulate employee conduct and behavior versus this federal guaranteed right of employees to, engage in protected concerted activities? And hopefully you're starting to see where I'm going, because employee handbooks and employer policies can potentially be in conflict with these federal rights that employees have. Okay, if the employer steps on those rights, if the employer disciplines or discharges an employee who's engaging in protected conduct, let's say an employee complains about their wages to the supervisor, and the supervisor turns around and says, "We can't tolerate that, you're out of here, you're fired." Well, that violates the law, right? Because the law says it's an unfair labor practice for an employer to interfere with, restrain, or coerce employees when they exercise their guaranteed rights under Section 7. Employees have speech rights. What if employees, I gave you the example that employees might complain about their wages. Employees might complain about your benefits, or they may decide to walk off the job out of safety concerns. Those are all protected rights under federal law. They apply to merit shop as well as union contractors. Okay, so Section 8A1 is the typical violation for employers who violate Section 7. Okay, now let's kind of backtrack here. So when it comes to employer policies, it's not like this is a new issue, right? I mean, when I said, "Oh my gosh, there's the watershed moment this past August with a couple of cases, one involving policies," that is not to say that the board has not for decades been addressing whether certain employer policies that are found in handbooks, policy manuals, or whatnot are too broad or overbroad such that mere maintenance of the policy violates the law, even if you've never enforced it. All right. And they started looking at these really closely back in the 1990s. And the decisions have literally gone back and forth. And when I say that, it's because the way the NLRB works, the party that controls the White House gets to appoint a majority of the NLRB. It's a 5-person board, which was created back in 1935. And if a Democrat or Republican is in the White House, and they appoint 3 well, they get to appoint a majority basically from their political party. Now, they also get to appoint all the members of the board. So by tradition, for example, Donald Trump, he appointed 3 Republicans and 2 Democrats, right? So there's always a 3-2 split with the NLRB. Currently, there are only 4 members of the board in place. A 5th has never been confirmed. So it's a majority of 3 Democrats and 1 Republican. So whoever's in the White House gets to control who's making the NLRB decisions. And you can see that the pendulum goes back and forth, back and forth, back and forth, depending on who's controlling the White House, meaning that they will reverse decisions routinely and overrule decisions. So employers will be operating under a set of rules because of a case that came down, and then boom, maybe 4 or 5 years later, 10 years later, that decision is reversed, and you have to now do something completely different. Is it efficient? No. Does it lead to predictability and consistency? Absolutely not. But apparently, that's what Congress intended when they wrote this, law, the Wagner Act or the National Labor Relations Act back in the mid-1930s. So the issue that we'll be talking about this afternoon is whether, just merely having an unlawful merely having an overbroad policy, a policy that may impact people's ability to engage in concerted activities, violates the law, even if you don't enforce it. And that will be critical now moving forward, much more so than it used to be. Now, the first case in 1998, again, this was President Clinton's board, right? So there were 3 Democrats and 2 Republicans on his NLRB. And in this case, the Lafayette Park Hotel case, there were, the employer of that hotel had various rules in its handbook regulating employee conduct, respectful workplace policies, and you won't intimidate or harass coworkers, you won't engage in insubordination, stuff that frankly you probably have in your handbooks. Nothing remarkable about these policies. But union and a union organizing campaign, they identified policies that say, hey, these policies, NLRB, might restrict people's ability to unionize, right? I mean, if you have a policy that says you cannot speak ill of the employer, well, that might tell an employee that I can't unionize because I can't go tell folks we need a union because the employer's not treating us fairly. So, there were various work rules that were at issue in the Lafayette Park case. And the board said that the appropriate inquiry is to ask whether the rules would reasonably tend to chill employees in exercising their Section 7 rights. Very broad standard. You don't really know what that means, right? you have to ask, is there a likely chilling effect? Are you going to, are people going to refrain or just decide, I'm not going to go and talk to my coworkers about this. I'm not going to go sign that petition. I'm not going to go complain about, my scheduling, um, which are rights, okay, that employees have to do. So the question is, does the policy have a likely chilling effect such that just merely having the rule is an unfair labor practice? And the inquiry there is, would the rule reasonably tend to interfere with people's exercise of their Section 7 rights? The word would is very important, right? Because that sort of suggests that a reasonable person looking at the rule will refrain from engaging in activity. And easy examples, for example, is a policy that says employees are not allowed to discuss their wages with any coworker or others. That policy, even under the Trump board, even under the Republicans, is per se unlawful. Just having that policy is unlawful. And it's another violation if you go ahead and enforce that policy by disciplining somebody for talking about their wages. And that rule, for example, in looking at it, the rule would reasonably discourage people from complaining about their wages or talking about their wages. Okay. So the word would is very important here. And then let's shift gears a little bit. And we have the Lutheran Heritage Board, decision, which came out under President Bush. And the Republicans here didn't really retreat too much from the Lafayette Park Hotel case. And in here, in looking at employer policies, the NLRB in 2004 said, okay, whether or not the law is violated will depend on either one of three things. Number one, does the rule or would somebody reasonably construe the rule to prohibit their engaging in some protected conduct? So the terminology there is, would our employees, would they reasonably construe the language? Again, it's still a pretty high standard, because then you'd have to look at the language and say the likelihood is anybody looking at this language would interpret it to mean I cannot go and engage in that conduct. Or was the rule put out there by the employer in response to union activity? That raises questions, the timing of it, right? And then finally, had you enforced the rule to restrict their Section 7 rights? So taken together, it's still a pretty tough standard. It's still a pretty tough standard for unions to meet if they wanted to say that, hey, we looked at this employee handbook in NLRB and these provisions violate the law. The NLRB would say, well, would a reasonable employee interpret the language to prohibit it? Or is it only just a possibility that they might interpret it that way? All right. Not a bad decision, for employers, because the bar was still pretty high here. Now, fast forward 12 years to the William Beaumont Hospital case, which was under President Obama and his board. And in that case, the hospital had a rule that prohibited conduct that impedes harmonious interactions and relationships. As you can see, the NLRB said that's unlawful. So a policy that says, we don't want employees to engage in any activity that will impede harmonious interactions and relationships has been declared unlawful in 2016, because to the NLRB, employees would reasonably understand that the rule encompasses interactions protected by Section 7. So, picketing, complaining about working conditions, trying to get coworkers to sign a union organizing petition. The board would say that policy requiring, people get along would discourage somebody from signing that petition. And the employer, in that case, argued, well, wait a second, we have interests here too. We want to maintain workplace efficiency. We, need people to work in teams and to, be productive with each other and be respectful with each other in order to foster a great workplace and to get the job done. But this case, NLRB didn't take a look at that whatsoever. They just focus solely on this kind of strange or tough standard, which is, would an employee reasonably understand that the rule is protected, would interfere with protected activity. And in this case, the Obama board said, yeah, that this respectful workplace policy was unlawful. If we went back and looked at that Lutheran Heritage, or excuse me, the Lafayette Park Hotel case, or Lutheran Heritage, Lutheran Heritage case, you would see that the Bush board probably would not have found that policy to be unlawful. Okay, with a reasonable employee construe it to be that way. So that was in 2016. The board in that case, by the way, also looked at a non-disparagement policy, which is we don't want any negative or disparaging comments made about vendors, coworkers, managers, etc. Board said that is going to be a violation because employees have the right to disparage their supervisors. As I'm sure every person who's managed any employee in their history has already determined that is protected conduct. And so the rule would reasonably be construed to prohibit protected expressions of concern about the workplace. And again, as I said, no general considerations given to the employer's position here. All right, so, a year and a half later, and the trend was going, and by the way, these are just the big cases, the cases that are established a rule. But since 1998, the NLRB would routinely issue decisions invalidating employer policies and holding employers accountable for a variety of policies, which included, policies that said that, you're not supposed to use foul language in the workplace. You're not supposed to denigrate anybody. You're not supposed to disparage anybody. General rules of civility. Particularly the Clinton and the Obama boards routinely found those to be unlawful. Now, Trump takes over and he gets to appoint his majority. And at the very end of 2017, he issued a big decision that effectively obliterated much of the prior 20 years or so worth of decisions in this Boeing case. And in Boeing, the policy that was really at issue involved the company's policy prohibiting cameras in the workplace. And you can imagine why, right? I mean, trade secrets, Department of Defense, confidentiality, privacy, requirements. Boeing had good reason to have a policy saying, employees, you cannot, with your phones or otherwise, take photos in the workplace. There are also concerns about, people being photographed or recorded without their consent, that sort of thing. And the Boeing board, or excuse me, in the Boeing case, the Trump board clearly wanted to undermine and reverse all of these decisions that were being created starting in the late 90s, in which they were looking at this reasonable person standard. Would a reasonable person consider or conclude that this impedes that person's ability to engage in protected conduct? So the board, looked at these rules and they came up with a balancing test, which categorized rules into one of three different categories. And they considered primarily the Boeing case in this balancing test, said that we're going to look at both the potential impact on people's rights, to engage in protected conduct, but we're also going to look at the employer's legitimate justifications for the rule. Was there a sound reason, business-related reason for the rule? And the Boeing case specifically overruled Lutheran Heritage, and then classified came up with these three categories: policies that were always lawful, policies that were kind of in the middle, that were subject to individualized scrutiny. In other words, they could be interpreted several ways depending on the context, and then policies that were always unlawful. Now, I gave you some examples of policies that were always unlawful. Board, the Trump board here cited the rules prohibiting discussions of wages among employees. That's per se unlawful. You can't. There's no legitimate business reason for saying employees can't do that. Um, you know, rules saying that employees cannot complain about their workplace, or rules saying they cannot complain about safety, factors. Those are all unlawful. There's no legitimate business reason that an employer could put out there that would override or outweigh the employee's interest in being able to express that. It's this middle category, policies that were subject to individualized scrutiny, that created some complications. And it was in this category that the board said, okay, under Boeing, we're going to balance the nature and extent of the impact on employees' Section 7 rights versus the employer's business justifications for the rule. Now you can see that in this case, the board determined that Boeing's no camera policy had legitimate business reasons and outweighed any what the board considered to be negligible interests of employees to be able to take photos in the workplace. And what interests were put out there, by the union, in this case, the machinists, in arguing that the rule should be invalidated. Well, the union said that, employees, if they want to be able to document safety concerns, they want to be able to take a photo of it. If they're witnessing unlawful conduct by a supervisor, they want to be able to record that. But the Trump board in this case said, yeah, those are few and far between, but whereas the employer's interest in meeting DoD requirements, protecting its trade secrets, far outweighed any, minimal or peripheral impact on employees' rights to, document safety concerns. That just did not happen frequently enough to override the employer's interest in that case. Let's take a look here. Oh, yeah. It's not quite. Sorry about that. Okay, so the following that, a couple of years later, again, as the Trump board, they took occasion to again look at some more workplace conduct rules. They refined that test even further, and it made clear that a challenge rule can't be found unlawful just because it could be interpreted a certain way. Okay. Instead, the general counsel of the NLRB, if he or she wants to issue a complaint against the employer, will have to prove that the facially neutral rule in context would be interpreted by a reasonable employee to potentially interfere with their rights. So looking at the context of the rule, the GC must prove that that rule would violate people's rights, make it likely that the rights would be violated. So, it's pretty ambiguous. There's not a whole lot of guidance there. But a facially neutral rule would be along the lines of a workplace civility rule. We expect employees to engage in harmonious relations with coworkers, managers, customers, vendors, etc. That's facially neutral. It doesn't say anything about protected rights. It's very generic, frankly. And whereas, the Lutheran Heritage and the older cases would have found and did find that rule to be, restricting people's ability who might want to go and organize or might want to go and complain or file a complaint with an enforcement agency. If it's facially neutral, and if, the employer has some, just sound business reasons, then the board, in this case, using Boeing under specialty produce, would go ahead and uphold the right of the employer to maintain that rule. Okay, so that was like the high watermark for employers. Employers were taking, breathing a sigh of relief because their policies, weren't going to be subject to very close scrutiny. HR folks all around the country were, putting handbook reviews and legal reviews of handbooks on the back burner because the NLRB took their foot off the pedal on this one. And, employers moved on to other things until, of course, this past August, where, we had a Biden NLRB, right? And there were several employer policies that were at issue in, this case. And we'll get into it, by the way, a little bit later on why a union would really care about what these policies are. Okay, it's mostly unions who bring these charges alleging that policies violate the law, violate employee Section 7 rights. So we'll talk shortly about why unions would take such an interest. But in this case, there were several rules that Stericycle, the employer, had in their handbook. And I'm going to summarize the key ones here. There were rules prohibiting the use of profanity or inappropriate language while on Stericycle premises, whether on duty or not. Rules prohibiting engaging in behavior that's harmful to Stericycle's reputation. Okay, so these rules basically say no cussing. You know, don't use the F word. We want everybody to be civil here. And we don't want you out there defaming us or making us look bad in the public. That's the gist of those rules. Rules prohibiting the refusal to follow the direction of a supervisor or otherwise being insubordinate, right? So rules prohibiting insubordination. Rules prohibiting participation in an activity that constitutes a conflict of interest or which adversely affects upon the integrity of the company or its management. Now, I'm inviting you to go back and kind of revisit some of your handbooks. You might have some things that sound close to what we're reading here. They also had a sexual harassment policy. In the investigation portion, this policy said all parties involved in the investigation will keep complaints and the terms of the resolution confidential to the fullest extent practicable. So, and other policies out there say, well, we're investigating. We don't want any witnesses or the complainants to talk about this case to anybody because we don't want, we want to preserve the integrity of the investigation. So those are the policies that led to the unfair labor practice charges, and which then led to the NLRB overturning Boeing, overturning LA Specialty, and even going beyond what the prior union-friendly NLRBs were doing to create a new standard here. Now, Stericycle, the board here, they didn't like what Boeing had to say. They really had spent a lot of time attacking it. They said that the Boeing rule allows employers to adopt overbroad work rules that chill employees. That's kind of the general complaint they had. The company, in defending their policies at Boeing, did not take into account for the economic dependence of employees on their employers. So what the board is saying here is that, listen, employees, their livelihoods, their paychecks depend on their employment with you. And so they're going to really be reluctant to do or say anything that might violate a policy for fear of getting fired. And that is an imbalance to the board, right? Employees are going to be prone to not engaging in protected conduct because they're economically dependent on their employers. Employees are typically anxious to avoid discipline and discharge. So they're reasonably inclined both to construe an ambiguous work rule to prohibit statutory conduct and to avoid the risk of violating the rule by engaging in the activity. Now, I think they're in this particular rationale for why they're overturning Boeing. I think they're reading a lot into employees. I don't think employees are that sophisticated, right? But we'll see. The board goes into much more detail about this, as does the dissent in this case, which I thought did a good job of attacking the decision and predicting where many of the cases are going to go. So Boeing gives too much weight to the interest. Boeing condones overbroad rules by not requiring the parties drafting the rules, which is the employer, to narrowly tailor its rules to only promote its legitimate substantial business interests while avoiding burdening employee rights. Okay, so Boeing didn't really properly balance things. Boeing did not require the employer to have the narrowest possible rule in place that would still allow the employer to achieve its objectives, but which do not step on employee rights. Finally, as I said earlier, they attacked the Boeing case by saying, it does not take into account the perspective of an economically dependent employee who contemplates engaging in Section 7 activity. That's a pretty ridiculous standard, if you ask me. All employees are economically dependent. So is that, so meaning there will always, by there always will be the presumption that employees who are economically dependent, which includes you and me, are not going to risk getting fired by going and talking to a union or going and talking to a coworker about why they don't like the medical leave policy or anything like that. And the dissent sees this. The dissent sees this as a lot of words, but the gist of it is it will be impossible for employers to have any policy that, if it's close, will be ruled to be lawful. So the new rule articulated, and this is the rule you have to follow, is that they're going to look at work rules and they're going to try to determine if a work rule has a reasonable tendency to chill employees from exercising Section 7 rights. And they're going to look at the rule from the perspective of a reasonable employee who's economically dependent on you and who is inclined to interpret an ambiguous rule to prohibit protected activity. How many employees do you have who look at your rules and are immediately thinking in terms of, okay, how will this limit my ability to engage in Section 7 rights? They're saying all employees who are economically dependent and without much guidance, the presumption is all employees also will be interpreting it, interpreting anything, any ambiguity to prohibit them from engaging in activity and conduct. If an employee could reasonably interpret a rule to restrict protected activity, the rule is presumptively unlawful, even if the rule could also be reasonably interpreted not to restrict that activity, and even if the employer did not intend for the rule to restrict protected activity. So remember, early on, we went from the standard under the Clinton board, with Democrat majority, saying, would the rule be reasonably construed? Now we're at, could it be reasonably construed? Even if there could be an equally reasonable construction of that rule as to not prohibit it. So let's use the classic example. Again, going back to respectful workplace policy. We want employees to get along. We expect everybody to work in a harmonious fashion. And don't use vulgar language. Well, could that rule be interpreted to restrict my ability to go and tell my manager to F off, which, by the way, prior to the Trump board had been upheld by earlier NLRB saying that's legit because supervisors are fair game. It's sort of the law of the workplace. Could that rule be reasonably interpreted to restrict my ability to do that? Now, recognizing I collect a paycheck from the employer, so I'm economically dependent, and the law presumes I'm thinking about in purposely engaging in conduct that I know will be supported by the statute, which no employee does. So that means every rule out there could be interpreted to restrict Section 7 activity. And the dissent saw this. Okay, I'm including here excerpts from the dissent. And this kind of helps you because there's some guidance in here. Unfortunately, the guidance from the dissent is sort of a roadmap for how employers are going to get screwed under this standard. Okay, so according to the dissent, the board's reasonable employee, so-called reasonable employee, is an employee predisposed to read into their rules references to Section 7 activity where none exists. And then if a word or phrase could possibly be interpreted to prohibit activity, then the rule is presumptively unlawful, even though a truly reasonable employee would apply common sense and recognize the evident purpose of the rule has nothing to do with Section 7 rights. Sorry. The dissent asks, how will an employer prove that it's unable to advance its legitimate and substantial interest or interest with more narrowly tailored rule? Would the employer have to show that it maintains the rule because a prior narrower rule failed to advance the relevant interest? That would require you then to document the business reasons for why you adopted the rule. And you would have to document you tried to make the rule narrower, but were unable to, while still achieving your interest. You have a lot of policies, do you not, in your employee handbook? Yeah, it could be job security for whoever you've assigned, that you assign your company to go and conduct this analysis. Would it suffice for an employer to introduce evidence that it considered, but it didn't actually implement a narrower rule and rejected it as unlikely to advance the relevant interests or interests? So, and these are rhetorical questions, by the dissent. The dissent is saying, well, because the dissent started off by saying, listen, majority, you didn't give us any guidance here. What's a reasonable person? I mean, what do you mean by narrowly tailored? Is it going to be enough for the employer to say, well, we considered it, but we didn't think it was going to advance our business interest? Yeah, this is the dissent's way of saying all employers are going to need to do that if they want to be able to defend their rules in front of the NLRB once unions go and start to raise unfair labor practice charges. And another one, which is sort of interesting, if the board holds that your rule is unlawful, then you go back to the drawing board, you draft a narrower rule and put that into effect, but it doesn't work because your business interests aren't being advanced. Does that mean that the rule the NLRB had invalidated is actually the narrowest possible rule? And if you were to reinstate it, are you violating the board's prior decision? I mean, this is a classic catch-22 that you're going to find yourselves in, and I think it's likely you are going to find yourselves in. Now, here's one thing I liked about the dissent. Employers would be well advised to avoid a finding of presumption of unlawfulness by retaining competent labor counsel to craft for inclusion in their handbooks language that would make it impossible to interpret. And I support that dissent. In particular, I almost highlighted it for you, but I didn't want to be too obvious about my being enamored with that. All right, and we'll get into the list a little bit later about what are the policies you got to target. But there have been some other recent employer work rule cases. I'm not going to dwell too much on McLaren-Macon because we talked about this actually at a prior ABC workshop. I think it was in June, but this was a case involving a severance agreement with non-disparagement and confidentiality provisions. And in this case, the NLRB said that any agreement with broad non-disparagement and confidentiality provisions, those provisions will be considered unlawful because they would restrict employees' exercise of their rights. I mean, they would in this case because in the severance agreement, the employees are actually signing a contract saying they won't. And the chief enforcer of the NLRB, the general counsel, who's basically the prosecutor, says that any confidentiality provision in the separation agreement has to be narrowly tailored, targeted to proprietary trade secret info, limited in scope, and based on legitimate business justifications. So if you have a handbook policy that just says that, we expect, when you come upon information, and data and whatnot as part of your job, all employees are, required to keep that confidential. You're going to have to define what you mean by confidential information. Otherwise, if you look now at the Stericycle case, if an employee could reasonably interpret that to prevent you from talking about talking to a union about your wages, for example, then that confidentiality provision would violate the law. Non-disparagement provision, same way, same deal. Any non-disparagement provision that's general, such as we want you to get along, we don't want to use profanity or whatnot, that would likely be considered unlawful because that, if you look at the Stericycle standard, an employee who's economically dependent on you, and who would be thinking about complaining about that working condition or filing an unfair labor practice charge or filing a discrimination complaint, then that non-disparagement clause would also be considered unlawful. So that's another set of policies you're going to have to go back and take a look at, non-disparagement and confidentiality provisions. Employees are not allowed to waive those. So they can't just sign an agreement where you give them money and they agree not to disparage your reputation, not to disclose confidential information. And the reasoning of that, of the case, general counsel asserts might actually extend to non-compete agreements as well, non-solicitation, non-poaching agreements. We already have it state law. I just threw it in here for reference, just to refresh everybody. But there's already a state law in place that that puts restrictions on non-disclosure or confidentiality agreements. So that if you have an agreement, a separation agreement, a settlement agreement, a harassment issue, discrimination matter, any kind of agreement that limits disclosure of discrimination, illegal harassment, retaliation, wage and hour violation, sexual assault, or anything deemed to be against public policy, that agreement then is void under Washington law. Tesla case last year, I'm not going to dwell on this one, but it says that any employer policy imposing restrictions on people's, your employees wearing union buttons are presumptively unlawful absent special circumstances. So those special circumstances would be, hygienic purposes, and that's primarily it. So if people want to start wearing buttons or stickers, you're going to need to allow them to do that, and you cannot maintain a policy telling them they cannot do that. All right, now, before I get into the specific policies, here's why the handbook case that we just reviewed is really important. Because 2.5 weeks later, an even bigger decision came down, and everybody, in this meeting right now, they need to understand that the rules have really changed regarding union organizing. This is a case involving Cemex Construction Materials. And I think Cemex is actually a company based in Mexico, but they're worldwide. And in this case, the board, as you could read here, reversed 50 years of case law on how unions could be recognized and when elections would occur. Now, the way it works, and maybe some of you here in the meeting, and I know several ABC members, over the years, they get approached by a union, and the union will say, employer, we have authorization cards signed by a majority of your employees who want us to represent them. And the rule up until August 25th, 2023, was that employers were allowed to say, thank you, no, we will respect, the decision or the wishes of our employees, through an NLRB conducted secret ballot election. That's all the employer had to say. And sometimes unions would just go away. Sometimes they would go and file a petition for an election with the National Labor Relations Board. And then an election would occur, and a majority of the people who vote will decide whether or not that proposed bargaining unit is unionized. So the old process was the union comes, and oftentimes they didn't, but many times they would ask for voluntary recognition. Employers would say thanks, but no thanks. If you're going to unionize your folks, you're going to need to go and get an election done. The board in Cemex completely obliterated that. And I don't think this case is going to hold up in court, by the way. The board came out with a new rule that gives employers 3 options. When a union comes knocking, they walk into your receptionist. Can I speak to David, the CEO? Or Jody, the CEO? And you go out, yes, may I help you? Here, they throw cards in front of you. We have cards signed by a majority of your employees who want us to represent you. We're asking for you to voluntarily recognize us. You can tell them the door's over there. Don't let it hit yourself on the way out. And, if you're going to file an election, go for it. No longer. Now you have 3 choices. Number 1, you can say, okay, we'll recognize you. It's easy. And some employers do. Not in your industry, but some employers out there do it almost for business reasons. Second option is the employer, within 2 weeks of being requested to voluntarily recognize, the employer can file its own petition with the NLRB. It's called an RM petition. Don't ask what RM stands for. You don't need to know because it doesn't have anything to do with elections. Just call it an RM petition. You get on the board and you say, this is an employer petition. We want the employees to vote on this. As I said, that has to be done within 2 weeks of the demand for recognition by the union. And the purpose of the petition is to test the union's claimed majority support or to challenge whether or not it's an appropriate bargaining of the union's going after. If you don't, within those 2 weeks, file your own petition, then you're going to lose the ability to seek an election. That union recognition clause or the union recognition demand. The third option is just to do nothing. We're not going to file our petition. We don't think there's support out there. We don't have to get back to the union. We're just going to stay silent. But if you do that, you are at significant risk. What will happen, and this is in the Cemex case, and this is what the board says can happen. If you do nothing in response to the demand, then the union can go and file an unfair labor practice charge saying that you're unlawfully refusing to bargain, but you rejected its demand for voluntary recognition. And the burden's on you to prove that the union in that unfair labor practice, that the burden's on you to prove that the union did not have majority support. Now, up for the last 50, 60 years, the union always had to prove it had majority support. You have to now disprove it. Or you have to prove that the bargaining unit the union wants is not appropriate under law, which is very difficult to do nowadays. And if the NLRB in that unfair labor practice investigation and ultimately decides that you should have recognized the union because you, employer, were not able to disprove it, then that constitutes an unlawful refusal to bargain, and the NLRB is going to issue a bargaining order. Meaning the NLRB is going to order you to recognize the union and to start bargaining. Now, where in there was there an election? Can you see the word election in that paragraph at all? That employees actually got to vote on this? Now, the NLRB, they don't want elections. This is where I'm kind of editorializing now, and I'm sorry. But my colleague, Darren, who some of you know, and I was telling him about this, he says, oh, go ahead and editorialize. ABC loves this. You should, because I'm often held back in less friendly surroundings. But in this case, if you don't do anything in response to demand for recognition, the union will file an unfair labor practice saying the NLRB, the employers should have recognized this because here are the authorization cards. And the burden will be on the employer to disprove those cards. And the way to do that, you would have to show they were done under duress, the union coerced them, the union threatened them. Unions are pretty savvy. They don't do that overtly. And if you lose that ULP case, then the board is going to order you to recognize the union. Now, in the interim, if you go ahead and you start changing terms and conditions, you grant some wage increases, or you're going to change your benefit plan, it's open enrollment, we got a new plan year coming up, or we're going to change the way we schedule things, then that also is grounds for failure to bargain, and a bargaining order will result. Now, does this process lead to quick determination of the union's majority status? Of course not. Unfair labor practice charges can take months, and you can keep appealing. So all the while, there's no election. The union is alleging that you violated the law because you should have recognized us. And the NLRB will conduct a hearing. If you lose that hearing, then you can appeal that loss for the ALJ to the full NLRB in Washington, D.C. If you lose with the full NLRB in Washington, D.C., you can appeal the Federal Court of Appeals. You can appeal that up to Supreme Court. So, potentially you're looking at 8, 9 years later that this matter will be resolved. Completely annihilates the board's argument that this will lead to quicker recognition. Here's the key. If the employer commits an unfair labor practice that requires setting aside the election, this is independent of, this refusal to file your own petition. If you, the employer, commit an unfair labor practice requiring that an election be set aside, the petition will be dismissed and the employer will be subject to a remedial bargaining order. That is actually if the petition is filed. Why is that important? How does that relate to what we're just talking about? Well, first off, as I said earlier, the burden's on you now, the employer, to request a union election. The failure to request an election will result in automatic recognition of the union. Now, unions, because of what we just read, which is if you commit a ULP, then the board will order you to recognize the union. Unions in almost all cases, they already do in many cases, will start filing unfair labor practice charges to see what sticks. Union comes, they demand recognition, and then they're also going to go and file some charges saying, gee whiz, guess what? You're maintaining unlawful handbook policies. And if the charge is upheld, the board says, yeah, you're maintaining unlawful handbook policy. You now have to recognize the union. And again, on this page, is the word election is in there, but that's you failing to request an election. Nowhere in here will unions get the employees given the right to vote. Okay. Any finding of an unfair labor practice while union recognition is pending will lead to automatic recognition and an order to bargain. So let's think about that. As I said, it's not just cases where a union files a petition and you start firing the organizers. You know, you threaten people, you retaliate against. No. The general counsel, in interpreting this, the NLRB's chief enforcer, points out in the guidance that came after this case that even a single, even less serious unfair labor practice can result in automatic recognition. And if you maintain unlawful handbook policies, yeah, you're going to end up, and the union's organizing, you're going to end up becoming union because of this decision. So you'll be, you know, if the union's going after you, you can expect they'll start filing for labor practice charges, alleging unlawful overbroad employer rules, and that'll be part of a strategy to force automatic recognition. We don't know how isolated or how trivial, you know, a violation has to be, or the unfair labor practice has to be for the NLRB to say, well, we won't order recognition in this case. The wording of this suggests very strongly that practically any ULP will lead to automatic recognition in this circumstance. This is just a little legal note here. These are a couple cases that the board is completely ignoring and frankly violating, if you will, because they're Supreme Court cases. And there's ample reason to believe that this CEMEX case is going to be thrown out. And I hope that whoever challenges it ends up in front of the Supreme Court, because then the Supreme Court will make it the so-called law of the land. If an employer challenges it and wins, you know, in a court of appeals, the NLRB decision still stands. This is the way it works. The NLRB decision is still good for everybody outside of that case and outside of that court of appeals jurisdiction. So DC Circuit Court of Appeals tells the NLRB, no, we're invalidating this case. That only has impact on the employer who appealed it. It will not impact how the NLRB still enforced it everywhere else in the country. Okay, so what do you need to do? What kind of policies that you really have to focus on? Okay, disclosure of confidential information, use of employer technology and tools. I'm sure have a policy saying that your email is intended for business use only. Your policy might even tolerate very limited, you know, personal use of email systems or in the internet. Well, the board is already saying that email systems are fair game for employees to use for organizing and other protected activities. Social media and related activities. You might have a policy that says that, you know, you have to identify if you're on social media and you're talking about our company, you have to identify that this is not your opinion or this is not the company's opinion. You're not allowed to use our trademark, you know, on social media. The board is going to validate those policies. Media and third-party engagement. You know, if any member of the media contacts you employees, we want you to refer that, you know, to our president or our public information officer. The NLRB is going to find that unlawful. employees have a right. And frankly, even the Republican NLRBs in the past have said that employees have a right to talk to the media about, their beef with the employer. Solicitation and distribution rules, those are always scrutinized. But you have a policy that tells, that undoubtedly tells folks that they can, solicit each other for non-business purposes. Hopefully the rule says on, on non-work time and in non-work areas. But you better look at that policy, because if it doesn't say that, then the policy is going to be ruled unlawful. Harassment policies. If you have a policy that says we're going to maintain the confidentiality of the investigation, and we're going to expect witnesses and participants to also maintain confidentiality while we're investigating, that's going to be considered unlawful. That's really near and dear to me too, because it was my case, the average retail case in 2021. The NLRB looked at it. The NLRB reversed the Obama board on that and said that those policies are lawful. So, Stericycle specifically reversed Apogee Retail. So I had a little personal beef with the NLRB as well, because that was my case. Employee disciplinary rules, yeah, you got to look at those. Absolutely. Now, I'm not giving you examples of these rules. They're probably labeled as such. You're going to need to collect these, and you should start looking at all of your policies from the perspective of could an employee who might want to go and challenge this rule or go and talk to a union or talk to coworkers, could an employee think that infringes on their right to do that? Of course, the answer is going to be yes, right? Because every employee who's economically dependent, that's all of us, could interpret something as stepping on their legal rights, according to the Stericycle case. Dress code policies, internal complaint policies, these are policies that say that, hey, if you have a problem, workplace problem, we encourage you to talk to we want you to talk to your manager and use our suggestion box or intranet, confidential intranet. Well, an employee could interpret that to mean, you mean I can't go to a union and complain about that? 99.9% of the time, that's not how employees would interpret that, of course. But to the NLRB, if somebody could interpret it that way, then it's unlawful. Now, with all of these policies, you're going to need to at least do this. But this alone isn't going to cut it, right? And that is putting a disclaimer in your respectful workplace policy, for example. It says nothing in this provision is intended to eliminate or limit employees' rights under Section 7 of the National Labor Relations Act. It's good language. You put it in there, but the board is going to, again, they're going to say, is the policy narrowly tailored? Just because you have this disclaimer doesn't mean you're going to get a pass, unfortunately. But at a minimum, all the suspect policies are going to need this language. Give you an example later on too of what it could look like. So, a little quiz for everybody here. Is this lawful or unlawful? Never publish or disclose the employer's or another's confidential or other proprietary information. Never publish or report on conversations that are meant to be private or internal to the employer. Lawful or unlawful? Should be. Jody here says it should be unlawful.
Lawful. Wait.
Congratulations, it's unlawful. Now you have to scrutinize them, right? I mean, the NLRB made a point to say, well, there's no blanket rule. You got to look at case by case, circumstances, employer's business justification. But these kinds of policies have already been found by the board in other cases, this one to be unlawful. All right. How about confidential information? All info in which its authorized disclosure could adversely affect the employer's interest, image, and reputation, or compromise personal and private information of its members. Defining it that way. Is that narrow enough for you? Well, I mean, if I go and I tell the media, I don't like working for ABC of Washington because they don't treat us fairly and there's a glass ceiling. which is ostensibly, provably not the case at ABC Washington, right? But you're telling the media this. Well, that could adversely affect the employer's reputation.
Yes.
Okay, so we know that this one, whoops, it's kind of playing games here. That one is unlawful. All right. Don't send unwanted, offensive, or inappropriate emails.
I mean, I want it to be lawful.
The comment in this room, folks, was, I want it to be lawful. But unfortunately, it's unlawful as written, because that could be construed by somebody who wants to go and send an email to the boss complaining about treatment to limit their ability to do that, lest they get terminated. All inquiries from the media must be referred to the director of operations in the corporate office, no exceptions. I think there's a theme developing here. Unlawful. No employee using any recording device. Unlawful. Now, Boeing, I think the case could be made that, well, that was a most narrowly tailored rule because we have specific legal requirements we have to follow. We have, provable trade secret violations that we've had in the past. And so that justifies our policy. You can make that argument, but this particular policy, prior board decisions, has already been found to be unlawful. Soliciting, collecting funds, distributing literature in company premises without proper approvals or outside the guidelines established in the no solicitation or distribution policy. Lawful or unlawful? I'm kind of getting pessimistic. I haven't seen any lawful policy here yet. In order to preserve the integrity of the investigation, the company will require those witnesses and parties involved to maintain confidentiality of the investigation while it's ongoing. Unlawful. Sad to say that was my case. All right, lawful or unlawful? This one's kind of loaded. Very small letters. I'm not going to read the whole thing, but I'm going to give you 10 seconds to read it. And then you can tell me whether this is lawful or unlawful. Now, it's a no defamation policy, right? First off, and we already had the one McLaren-Macon case we talked about, where the board really looked closely at non-disparagement, which is could be a form of defamation. I don't necessarily recommend that people have, defamation policies in their handbooks. It's a landmine, and you can tell by just reading this, which would be lawful, we think. Why it, based on all the restrictions the laws imposed, why it has sort of limited effect, right? When you have to put all of this language in here in order to try to make the policy lawful. This also references state law. And then the last sentence is that little language, right? Nothing's intended to eliminate or limit employees' rights under Section 7. But to get down, the policy itself is like the first two sentences, and then 2/3 of this paragraph are all the disclaimers. So that's an example, frankly, of what some of your policies may end up looking like if you want to keep them in a handbook. So review the policies. Remember that keeping those policies during union organizing can lead to an NLRB order requiring you to recognize the union. So if I'm a union, I'm targeting a company, I'm going to want some of my employee contacts to give me a copy of the employer handbook because I know I'm going to find a policy or two in there that violates the law. You're going to have to go, that whole little bulleted list of policies, you're going to have to go pull those out. Frankly, have, anybody, me or anybody, another attorney review the handbook to see if any of these provisions are putting you at risk. And then if they are, then we have to figure out, is there a way to draft the policy so that it's much narrower? And in doing that, you're going to need to come up with your business reasons why you need that policy. Maybe you had bad experience in the past. So now you're going to limit employees from being able to do X, Y, Z. Maybe you have grant requirements or federal contractual requirements regarding confidentiality and trade secrets and all that sort of thing. You're going to need to look at all that kind of evidence and collect it and record it, because if the NLRB is ever looking at your policies, you want to be able to pull that out and say, here's why we have the policy. We tried to have it narrower, we couldn't, or this, it's much narrower. The narrowest we can have it while still complying with our contract, while still protecting our trade secrets, for example. That's going to be quite an effort. You can put the disclaimer in there, but that alone won't cut it. But the NLRB always likes to see at least employers aware that they're not supposed to violate Section 7 rights of employees. Prepare those written justifications, look at evidence, past incidents to help justify the rule. Then you can use those in an NLRB investigation. What else has been happening out there? Non-NLRB stuff. Well, if you're in the city of Seattle, and you have non-discrimination language, an EEO clause in your handbook, you're going to need to throw CAST in there. I'm getting skeptical looks at you. Well, first off, this is the city of Seattle, right? Are we really surprised by anything we hear coming out of the city of Seattle? Although maybe the election this week will at least slow that bizarreness somewhat. But caste is defined, and it's because of the South Asian population growing, in the area. You cannot discriminate anybody based on their caste, which is defined as rigid social stratification characterized by hereditary status, endogamy, and social barriers sanctioned by custom law or religion. So all of those of you who wanted to discriminate against individuals because of their caste now will not be able to do it if you're in the city of Seattle. The state, in its infinite wisdom, has passed a law prohibiting you from screening job applicants for cannabis use, unless you're in the aerospace airline industry, or if you have certain safety sensitive functions under DOT primarily that would involve, serious injury or death if they went ahead and violated.
Contractors?
Pardon me?
Contractors?
Everybody. The state law. Now, you can still test employees. You just cannot test applicants. Makes a lot of sense. I know that. It doesn't make any sense, but it's actually a first step. You know full well where this law is going in a few years. They're going to want to extend this to employees because it's legal to use cannabis outside of the workplace. So they don't want employers regulating off-duty conduct. Right now, the first step is to say that you cannot screen job applicants, you can't test them for marijuana use. Searching employee vehicles. It's another. You often have a policy in your handbook that talks about parking, maybe lockers. Well, this one is specific to employee vehicles, and the rule primarily has been over the years that you do that private vehicles, the cars that your employees drive to work and park in the parking lot. Because that's on company property, you have the right to inspect those vehicles. And you would normally do that if you expect some kind of theft, illegal activity going on in the car, evidence of illegal activity and whatnot. So the new law, which went into effect 3 months ago, says that employers can no longer search an employee's privately owned vehicle parked on your premises or on access roads leading to your premises. Now, if you have probable cause, which is a criminal concept, the federal constitutional concept, as determined or is defined by cases and by the constitutional interpretation, then you can search the vehicle for controlled substances. But probable cause is more than just we got an anonymous tip that somebody is selling drugs in their car in the parking lot at lunchtime. That's not probable cause. And you would call somebody like me who would then have to go and research what's the latest, what are the latest court decisions on what constitutes probable cause in order to be able to advise you whether or not you can go and inspect the vehicle. Having said all of that, I think it's still a good idea to have handbook language, which you probably have, saying that employees should not have any expectation of privacy for vehicles or property on your premises. It doesn't hurt to have that language. Nonetheless, you're limited, I think, significantly in your ability to go and go search those vehicles. So if you have a policy on that, to that effect, you're going to need to revisit that one as well. Well, good. Well, hopefully that was helpful for folks. You know, I can be very opinionated about this stuff because I've been doing this for years and years. And frankly, it gets very frustrating and tiring to have these laws change every 3 or 4 years. So you advise an employer on one thing, 3 years later, you have to give a diametrically opposite advice because of the political winds in Washington, D.C., which is why these elections are important, obviously, depending on where you fall. But, you know, we've learned there's no predictability in NLRB cases because the lifespan of these NLRB cases now are being measured in single-digit years once there's turnover in the White House. And that stair cycle will undoubtedly be reversed. If there's turnover in the White House, I guarantee you that the election cases are going to be reversed. And then we'll go back to the old ways, the Cemex case. But until then, for the next several years, we have to follow these rules. I'm sorry, as I've told folks many times over the years, it's horrible policy. It's great for people like me, but it is horrible policy. And you guys are the unfortunate recipients of policies, and you have to somehow operate under those. But when it comes to handbooks, whereas in the past, we were always telling you, review your handbook. So here's an NLRB case. It's not good. You got to go change that policy. Now there's a lot riding on this because if you are maintaining some unlawful policies, frankly, no matter how minor, and a union happens to be organizing you, then it is immediately increase the chance you're going to end up union without any election occurring. Or would just go ahead and order you to start bargaining and recognizing the union because you maintain an unlawful policy. I'm hoping that the board reins that in a little bit, and that what I'm saying now does not prove to be the case, but there are union attorneys out there who are well aware of these decisions, and they already are working in ULPs and your arsenal, and they want to be looking at your handbooks and as well as scrutinizing all of your other conduct and behaviors. So, but I think you already heard me say that a few times before in this presentation. Okay, well, if there are no more questions, thanks everybody for your attention. I really do appreciate it. And get a hold of Janessa. Actually, my email address is on the cover, I think, of this presentation. Feel free to shoot me an email if you want to talk more about it. But again, thanks for your attention on this Friday afternoon. I hope you have great weekends.
Thank you.
Thank you.